Hey folks, James Abrinio here. If you're a local Fairfax person, you may be aware of the Fairfax Commonwealth Attorney's Office. That's what we call here in Virginia. Commonwealth is our prosecutor. Recently, our Fairfax Commonwealth Attorney's Office and Steve Descano, the head of that office, announced that they released something called the Fairfax Commonwealth Attorney's Bond Data Dashboard. What I wanted to do was come to you all and just walk through it and see what I think, and I'll tell you what I think, and y'all can let me know what you think. So stick around. This video should be interesting. Hey folks, James Abrinio coming to you again. So what I'm going to do is go ahead and pull up this dashboard, and let me share the screen with you. Give me just a moment. Go. So here is my screen, and what I did for you all that are wondering how to find this thing, all I did was I put into the Google search Fairfax Commonwealth Attorney Dashboard. So if you, and I'll just do it again. If you do it, it actually comes up to the top. So here you click on this right here. And so there is the website for the dashboard. And so I'll just kind of do a quick overview of it. We've got the title here, but obviously right here is the actual dashboard itself. And then if you scroll down, you have a few statements from the Commonwealth Attorney's Office explaining how the data is important to the operation of how they're prosecuting cases and running their office and making decisions. A few statements from Mr. Descano himself in video form, and some interesting educational material. And what I'll say is this is as I'm looking at this is pretty useful stuff for the public to learn. You know, I know there's often in our communities when we're coming into politics, Northern Virginia is a hotbed, it seems like, for a lot of arguments for and against criminal justice reform. In 2020, we had a bunch of newly elected so-called progressive prosecutors. And so part of what they're trying to do, and there can be arguments for and against whether or not you're happy about how things are going. I have mixed reviews myself. There's a few good things. There's also some things I'm not so happy about, and everything in between. But this dashboard represents, I think, an effort for transparency and an effort to educate the public about what's going on, what is the process. So I'm liking what I'm seeing so far. And just FYI, I haven't studied this very much. I took a moment this morning to take about 10 minutes to look at the website, just get oriented. But what I'm seeing, it's interesting stuff, and I think I encourage anybody that's watching this video to make sure to look at this for themselves. And also, we'll put this in the show notes here, a link to this site. So going back up to the dashboard itself, let's go ahead and maximize that. Actually, I think that might mess up the feed, but what I'm going to do is, you can see here, this is essentially kind of a live action window. And so you can use this to actually activate. So you click up here, boom, and this starts essentially the presentation. So as you begin with, you essentially have a user's guide. This is cool. It's kind of giving you educational material about how to even read the dashboard. And so that's cool too. So take some time, read these details. I'm sure that's useful. And then as you go down here, you can click next, and that should get us to the actual dashboard itself. So this is the actual data that we're talking about here. The first thing that anybody should notice, the data is limited from essentially from January of 2022 to June of 2022, end of June. I suspect that's because they just started this thing, and so they're taking time to actually input data. Whether or not they're going to end up inputting data from prior to this, I don't know. I suspect one of the issues is going to be, I imagine they're gathering information that prior offices did not gather, and maybe the statistics just isn't there, but maybe they'll go back. I don't know. But again, looking at this, we're giving a caveat. Look, this is for the last essentially 6 months. But again, the effort to me is interesting, and I like that. So as you can see here, it's explaining the different type of courts. So you've got your general district court, and just a little procedural history if you're not aware of Virginia criminal law. When it comes to criminal court for trial purposes, there are three main courts. The general district court, that's where you get your traffic, that's where you get your assaults, that's where you get your misdemeanor possessions. You also have felony preliminary hearings there, but we're talking about for trial purposes. That's the jurisdictions there. Juvenile and domestic is where it's really crimes that involve family members. And then circuit court is where either misdemeanors are appealed to, or you have a felony that has a preliminary hearing and heard in either the general district or juvenile and domestic relations court, and the preliminary hearing gets bound over, and then the case goes to the grand jury that gets indicted, and it goes up to the circuit court. Now, when we're talking about this dashboard, this relates specifically to bond information. So whether or not when somebody's charged with a crime and they're going before a magistrate or they're going before a judge, and this really relates to a judge. So assuming the magistrate either doesn't give bond or they don't give bond to the extent that where the individual has enough money to secure a bond so they can be released. And now we're talking about cases where essentially bond motions have to be filed by defense counsel and to be heard by the court. So this is really related to what's going on there and the data related to that. So there's going to be a bunch of cases where this doesn't even apply because no bond motion has to be filed because a magistrate's deemed there's no reason to hold the person, or maybe they granted a secured bond, essentially where you have to either pay an amount or get a bondsman to pay a percentage, and then you can get out. And so long as you come to court, it doesn't matter. This is really limited to, it appears to be cases that just make it to the court and bond motions have to be filed. So here, essentially, and I'm looking at this really in detail for the first time with you guys. You have total numbers here. So numbers of defendants, and I guess this is over this period of time, and numbers of hearings. So interesting, you have a number of defendants, 802, but then you have number of hearings. If you're trying to understand how is that possible, I suspect what's going on, they're talking about cases where either in the general district or juvenile court, there was a bond motion filed and it had to then move up to the circuit court because either the bond was too high or a bond wasn't granted. I suspect that's probably the reason you have a higher number of hearings versus number of defendants, because each person may have to have more than one bond motion. And so hearings by type, general district court, 65%, juvenile and domestic relations, 16%, and then the circuit court is 19%. So what that essentially means is, and from at least the way I'm interpreting this, dashboard, out of all the numbers of hearings heard, a vast majority of them are heard in the general district court. Some had to move up to the circuit court, and some started off with initial jurisdiction because it dealt with family crimes in the JDR, the Juvenile and Domestic Relations Court. So as you can see on numbers, general district court is where you're going to see a vast majority of bond hearings. And that makes sense because whether or not you're dealing with a felony or a misdemeanor, most alleged crimes are non-family related, whether it's possession or drugs or alcohol, DUIs, reckless driving is even, but you're not going to have a lot of times you're not going to have bond hearings on those kinds of cases. But thefts, credit card felonies, things like that a lot of times you'll have to file a bond motion in the general district court. And even for felonies, if a judge grants bond and the person's able to bond out, then you're not appealing it up to the circuit court. Sometimes some people don't appeal it for strategic reasons, but long story short, you're going to have a vast majority of bond hearings in the general district court heard by our Fairfax County General District Court judges. One caveat I did want to say before going on, I did see some articles about an argument about, and again, you always hear the argument about progressive prosecution, and are they being too progressive, and is the Commonwealth Attorney doing their jobs, is the judges doing their jobs? And it seemed to be that there was an argument that everybody's arguing that the Fairfax Commonwealth Attorney's office is soft on crime. And then the argument seemed, at least the article then seemed to say, well, it's not actually the Commonwealth Attorneys that's soft on crime. It's actually because the judges are granting bond when the prosecutors, Commonwealth Attorneys, asking a person to be held. And the gist of it, I guess, is that if anybody's being soft on crime, it's really our judges. It's not the Commonwealth Attorneys, because they're asking that everybody be held or they're asking for a higher amount of bond, but the judges are lessening that. Look, the reality is in any bond motion, you're going to have a prosecutor that's going to be arguing for a higher amount of bond, and then you're going to have a defense attorney arguing for a less amount of bond. So let's say I have an individual that's charged with, let's say grand larceny. They stole a bunch of stuff from an electronics computer store. Now they've been arrested. And let's say the magistrate said, okay, we're going to give this person a $5,000 bond. So either they have to pay $500 to a bondsman to get out, or they're staying in. And let's say I'm representing that person. If I'm defense counsel, I'm going in and I'm filing a bond motion, and I'm asking either for a personal recognizance bond where they don't have to pay amount, or a lesser amount because maybe that person is indigent and can't afford the $500. And I imagine the prosecutor is either saying that amount is appropriate, or no, judge, the amount should be higher. It is usual for a prosecutor to be arguing for a higher amount of bond. It is usual for a defense attorney to be arguing for a less amount of bond. And so when a judge looking at that article, if anybody's trying to argue, I know the judge is being, too soft on crime, that doesn't understand the process, this litigation process. When you're looking at a case from a prosecutor's point of view versus from a defense attorney's point of view, you're going to obviously have different views of it. And then when a judge sees it in total, a lot of times they're going to see somewhere in the middle, or maybe they'll agree with defense counsel. Maybe they agree with the prosecutor as well. A lot of times it really depends on the particular type of case, but I don't want to give anybody the impression. I don't want anybody to have the impression that, just because our Fairfax judges are granting bond and quote the prosecutors arguing for more, and so now it sounds like there's some type of shift of blame. That is not the case. A judge is there to hear a case in totality and make a decision based upon the argument of counsel, upon the evidence granted, and to arbitrarily make some distinction of, okay, prosecutors being hard on crime and judge being easy on crime. That's just not a fair representation of the process. So I did want to put that caveat out there because I saw it, and I think it was a WTOP article. Here it looks like just another representation of the graphs based upon month. So percentage of bond motions per month. As you can see, again, it's pretty consistent. The General District Court is handling most of the bond motions, and then Circuit and JDR are handling less percentage-wise. Now, this is interesting. They also did a percentage of bond motions based upon the seriousness of the charges. So nonviolent felonies, violent non-sexual felonies, nonviolent misdemeanors, violent non-sexual misdemeanors, felony sex offenses, misdemeanor sex offenses. And so, how they're actually defining these terms of art, these notations, I don't have a definition section here. So I'm not going to get too far in the detail of that. I think that what you can see, though, is a vast majority of cases heard at bond motion are nonviolent felonies, maybe violent felonies. Now, that being said, even violent felony, I've got to imagine that may include, a robbery that, in our statute, when it comes to robbery, you can essentially have a situation where somebody pushes another person to take a cell phone or something, and that's considered a violent felony. So, again, I'm going to leave it at that for these. You can just see at least a representation of what these are as defined by the Commonwealth Attorney's Office. But as you can see, a vast majority are nonviolent felonies being heard. And again, that also makes sense when we're talking about numbers over here, and just going back to the discussion of a lot of these cases don't have to have bond motions. A lot of the simple crimes people can bond out on, assuming they have resources. Now, that gets into cash bond and all that discussion. And unfortunately, I imagine, and I'm not sure if they did this by finances, but I imagine a lot of people having to file bond motions end up having to file for financial reasons because they don't have the resource to get out. And that's the discussion about, is cash bond fair or not? But I'll leave that. Again, that's kind of outside the scope of this representation here, and probably, I don't know the data there, but if the Commonwealth is watching this, they might want to start considering who is the indigent into this, so we could get that kind of data. Maybe it's in here, I haven't seen it, but that's something to think about. Now let's go to the next slide where they're talking about age. Okay, this is interesting. So age, bond accused by age, gender, and then race and ethnicity, and then outside versus inside Fairfax. I guess that's residency. So this is super useful information here. And as this data dashboard grows, you're going to have more and more insight about what's happening, not just the last 6 months or first 6 months of 2022, but imagine that when this thing grows to 5 years, 10 years, when we talk about the arguments about how the criminal justice system is unfair when it comes to minorities. This is important data here. I mean, obviously we only have 6 months here, but when you look at this, we have at least, and again, I'm not exactly sure how they define these things, but at least based on the way their internal calculations are, you have 40% is Black, African American, Latino, 23% white, 3% Asian. That needs to be squared against the actual data population of Fairfax County and the defendants as a whole. It looks like a lot of, at least half of the defendants accused here in the system are from Fairfax County. So, when you look at this data, now you can kind of look at, well, what is the population percentage? How much of Fairfax is African American? How much is Latino? How much is white? And you start to think, well, how is it that you have almost half of the accused here being Black, African American, and 25% being Latino versus 23% white? And how does that square up against the population? And so then you start asking questions about how is that possible? And then we start talking about implicit bias and things like that. But before, and people make these arguments all the time, there's no implicit bias. Law enforcement is not racist. The juvenile justice system and criminal justice system is not racist. All those kinds of things. We can all talk about this from anecdotes, but when you start getting into data here, that's super useful. So, and the goal, in my view, about the argument about how our criminal justice system is and how it needs to be, my view is, look, we are where we're at now. If we have more efforts like this to look at data, to try to then improve where we're at now, that's really the goal, is to get better than what we're doing right now. So data like this is super useful. And I hope that, again, I don't know if they'll be able to go backwards, but as this grows with age, it's going to be more and more useful, I think. So assuming this is kept up and adopted, and I'd like to see this in other jurisdictions as well. So now let's go to the next slide. Zip code, so that's interesting as well. So you can see where the alleged crimes are originating and all that, how law enforcement uses that. I don't know how the public uses that. I don't know. That's for a lot of interpretation, but having that data, I think, is useful. Judge imposed cash bond. So I guess this is essentially where the judge ended up landing. And so you can see this data. So this is interesting. It gives you essentially where the judges are coming down on this information. So average court cash bond is around $5,500. Court cash bond amount, 113. Count, of course. Okay, so I guess this is 113 when they granted the cash bond. Maximum was 60,000. Minimum or median is 3,000. And I got to be honest, I'm not a stats person, so the difference between median and average, I'm not. I can have. You data people could talk about that more. And then minimum cash bonds, $10. I don't know what that was about, but that probably throws that off because it's not very useful. But again, this is interesting to see the data on it, and then you have it by types of offenses. So nonviolent felonies, you're getting. You can see here they're doing, they're deciding 5,000 on that. And then you can just tie into this data. This is super interesting. So I would encourage you to be looking at this data. And again, as it grows, you can see where the actual judges are deciding on this. Again, I just want to reemphasize, as I saw in that WTOP article, and that's where I'm pretty sure it's coming from now, I think would not be productive is an argument that a prosecutor is being, more reasonable when it comes to bond determination, and judges are being too light on it. I think our judges here in Fairfax County, we're lucky to have a very good bench. And I'm not sucking up. I mean, it is what it is. Some like me, some hate me, and everything in between. But I think they're very fair. I think they put real effort into getting these decisions right. We've also got a young bench now. We've got a bunch of people that are coming up on the bench that have a lot of diverse backgrounds. So I'm super excited about that. Some people that I know that so far are getting great reviews. But I worry about an argument being made for political purposes to then try to shift blame onto our judges who are making arguments or making decisions based upon the information that's being provided to them. And so I didn't really like the phraseology of that article, essentially saying that no, it's the judge's fault that people are being let out. I have a big issue with the way that criminal justice reform discussions are being had and how it's getting into the political world. And I don't think it's productive. And I think there's a lot of, I want to say misinformation, but yeah, maybe misinformation that's going on out there about how this is being played. But let's look at the data. If you got an issue about a specific case, then learn more about that case, because, and I can't encourage you enough, don't just go off headlines, learn about cases if you've got real issues. And I know for you diligent people that are really paying attention, you're doing that, but let's stop doing the clickbait, just so our arguments, and I'm on Twitter, so I'm probably not the best, at preaching my own or drinking my own medicine, but just take the time to learn about cases if you got real issues. So we'll move on from there. So this is, I guess, this is the Commonwealth Attorney's recommendation versus the court decision, and again, this kind of goes into what I was talking about. You're usually going to have a prosecutor that's arguing for more bond amount than a defense attorney, and then a judge is going to be the one has to decide what's appropriate. So use this information for what you will. But again, I just want to caveat it in a litigation system where it's typical that a prosecutor is going to go high and a defense attorney is going to go low. Now, don't get me wrong. Sometimes prosecutors do agree to bond, and there's no argument, but maybe that's another question we ask is if the defense attorney and the prosecutor agree, does that count in one of these hearings? That's a data point that I'd like to know. I don't know the answer to that. So take this for what it is. So this is more data about what the Commonwealth Attorney recommended versus, I guess, what the judge agreed to. So you can look at this data, and I think I need to, again, I'm looking at this, I'm going this deep in the first time, so I need to take a closer look at this to see before I comment more. Okay. So there is a glossary section. So let's take a look real quick. So at least from this definition of bond review hearing, I'm not sure that included in this data is whether or not when the defense attorney and a prosecutor agree, does that count as a hearing or not? I don't think it does. This has defendants for cash bond. Defendant is a person who's accused of committing or a prosecution. Just my own pet peeve as a defense attorney. Can we change this to accused, because you're innocent until proven guilty? So I think this should be accused, but they're calling it defendant. So this is glossary here. I guess there's more definitions. Magistrate, summons, trial risk assessment. So this has more information for data limitations and things like that. So one of the things I would recommend, again, if Commonwealth Attorney's Office is watching this, I would want to look at the definition, how you're defining felony versus non-felony, those definitions you're using. And so I think that would be useful for us to have a more precise understanding of this data. And again, I just want to emphasize, when we're looking at this data and we're using this data and whoever's producing this data, let it speak for itself. I don't want arguments about whether or not judges are soft and hard on crime. The last thing we need is judges having to be, you know, in a boxing match with the prosecutor's office about who's harder on crime, because I could easily see it going there. So, but that being said, I'm going to take a step back. I think this effort is a good effort. I think that there's a lot to be learned from this effort. I would like to see other prosecutors' offices here in Northern Virginia, but across the country, try to be using this. Maybe this was based off something else from somewhere else, but I like the effort. I think as it ages, as more questions are asked, as people start having better insight, better data points can be developed as we go on. So I think this only gets better from here on out. And then, you know, arguments about criminal justice reform and all that can be more data driven, hopefully, rather than, you know, you have one candidate saying, oh, you saw this person got released and went and hurt somebody, and then the other person saying, you know, we didn't have the information, or whatever the case may be. I'd rather us have a data-driven discussion about our criminal justice system, and this is, in my view, a good effort. You know, whether or not you agree with Fairfax's office and Descano, at the very least, we can give him credit for this effort, and you can hold him to that now. So you can look at the data and you say, look, you said you'd do this, but you're not doing that, and here's the data on it. And so that's good to know. Now, one of the other things you want to be thinking about, if I'm the Commonwealth Attorney, is how do I make sure that the data entry is as objective as possible and as reliable as possible too. But that's another discussion to have. But that being said, you can have arguments against what our Commonwealth Attorney is doing. You can be unhappy with some of the aspects of it. You can be happy with other aspects. But for this issue, I think this is a good start, and I'm happy to see that going down these efforts being made, and I would encourage other offices to take a look at this. So, any other questions, comments? You can comment below. You can subscribe and reach out to us. You can reach out to me. Actually, let me throw my information up here. This is my website, my phone number, and my email address. There's the handles for our social media. So feel free to reach out, give us a call if you got questions. If you have other questions, reach out to the Commonwealth Attorney's Office. If you want to see things happen, reach out, make your voice be heard. I think that one thing we can say in our politically charged climate, people are learning how to reach out to our representatives. We realize, look, it's not just a black box to where, you know, you're not getting any input back. These are human beings, so start making your voice be heard in a respectful way. And then, but I'm happy with this effort on this specific issue. So keep it up. There's some other things I'd like to talk about, but when it comes to data, good try and keep it up. And for you people that may be skeptical, keep watching it. It may add the data that you want to use in your argument against what's happening. So best of luck.